So our next speaker, who's a panel unto himself, is Phil Eskew. Phil has the next hour and 30 minutes to talk to you about the legal aspects of direct primary care. I've heard his talks now this will be the third year in a row, and I'm sure that they're getting more complex, not less complex. And these are issues that are very important to those of you who have ongoing practices with legal issues, questions we've heard from the floor in the last session, to those of you who are thinking about getting started but are concerned about some of the legal ramifications. So without any further ado, let me bring up Phil Eskew, or you know what, you can do it sitting or standing, whatever you want to do, Phil. Okay, all right, here's Phil Eskew.
All right, it's good to be with you today. We've got lots of updates out of 2018 here. For those who've seen me speak before, I'm hoping that at least half of this will be new to you. I tried to add lots of new topics today. So the first thing we're going to do is more of an introduction and sort of understanding why DPC... Is it working? Yeah. First thing we're going to do is an introduction and understand why states have defined DPC in the first place. It's, of course, to be outside of insurance. We're going to look at 3 examples there, a good one, a bad one, and an irrelevant one. And then we're going to look at some insurance commissioner guidance. There's more and more of this, especially in states that have not taken legislative action. The insurance commissioners are more likely to write a letter that's helpful to us. And then we're going to do a summary of what these things mean for you, especially if you're opening a new DPC practice, especially if you're in one of the states that hasn't said anything at all on these issues. Federally, we'll look at some HSA corrective efforts, look at some executive orders and what those could mean for new versions of RAP plans, I guess would be a way to summarize that group. And then CMS Pilot Conversations. And then the conflict of interest section is a new one that I think will be fun. Hopefully you guys will agree. And then we'll cover high tech, because everybody always enjoys using high tech for price transparency. So, not insurance stances. 23 states have explicitly said that DPC is not insurance. I'm going to have a chart later that shows those in color. They attempted to do it in Arizona but didn't cross the finish line. And Oregon is one of a few states that messed it up and still hasn't quite fixed it. And there are good guidance in 5 others. When I'm done with this section, we're going to have a comparison to the health sharing ministries, which actually fought a more difficult argument than we have on the not insurance front. So here's how it looks now. We're going to dig into Wyoming as an example. We're going to look at Oregon and Arizona, because they're different colors there. Oregon's the state that's got some lousy law in the books, and Arizona tried and kind of did a belly flop. And then the purple states are the ones that have guidance from the insurance commissioner but have not taken any legislative action. So Wyoming, that's the entire law. That's it. So if somebody tells you it needs to be long, it doesn't. All you're really doing is defining direct primary care, and they did it. Okay, they said either party could terminate an agreement at will at any point. They're describing the scope of services. They're not charging any fees beyond the periodic fee. They're not double dipping with insurance. It's fairly simple and straightforward, and it's there as a reference for you. Lots of other states have modeled their law after Wyoming at this point. I include Kentucky among that group, and it's working well. Oregon did something different. They were only the 3rd state out of this group of 25 or so to pass a DPC law, and there wasn't much guidance back then. They didn't really define DPC cleanly. They bundled it with concierge. You have to register as a retainer practice, lots of audit obligations, and so forth. Arizona, on the other hand, their original law was that paragraph there at the top. And the problem is the language in red. They said this is not insurance if the plan does not assume financial risk, which was the entire debate that the insurance commissioners make in the first place. So it didn't really get anywhere. And then when they tried to make a partial correction, they wound up lumping the board certification debate into the issue also. So they've got some work to do. Now let's look at the 5 states that have some guidance on the books. Maryland was the first one to ever say anything back in 2009. They had a report on retainer practices, and they issued lots of guidelines, which actually weren't that terrible, about how to avoid their office and not have to have them audit your practice. One of the things they wanted you to do was review the market value of your services, which is easy to do now and was harder to do back then. And they wanted you to define the scope, and the narrower it was, the happier they were. They wanted you to have a cap on the number of patients, which is easy. You can just state a panel size and you can adjust that as you want. They also wanted a number placed on the number of visits you would have during the year, which sounds bad because we like to market as unlimited, but I would advise you not to market as unlimited, and even if it winds up being that, that's fine, but don't put that on your website. It's just a target for you. Pick some arbitrary number, say 20 visits a year, and anything above that, reserve the right, which you probably won't enforce, to charge an additional fee if you need to, and that'll make most of the insurance commissioners happy. In 2015, they had revised guidance because they actually had somebody that they had to go after, and it wasn't a DPC physician, it was a dentist. And the dentist was offering something called a premium plus dental plan, which at first blush already sounds kind of bad. And then they used a lot of these red dirty words, these insurance words here: benefit coverage, plan coverage, offers excellent coverage for these dental procedures like crowns, canals, bridges, dentures. And that got them in trouble. Massachusetts, thanks to Dr. Gold, has a nice piece of guidance out here for physicians in that state. They did have a few areas that I wanted to flag that were worth flagging because they're kind of unusual and unhelpful. The areas that are black there, that are normal text, those are things you would expect almost any state to want right now anyway. You've got to say if you're participating in an insurance plan or not. You need to tell them that you're not an insurance plan and that you don't meet ACA coverage standards. That's pretty simple. What I thought was tacky in Massachusetts was that they want you to actually specify when the open enrollment windows are and tell them that what you're doing as a DPC doc is duplicative with their insurance. So that's frustrating. South Carolina, there's an insurance commissioner letter out as well, and this is another reference for everybody who might be from that state. The most important thing I want to highlight here, again, the black areas, the bolded areas are important, but they're common. You are probably already going to do these things, but the purple stuff at the bottom: program materials will not be distributed to insurance agents, and no solicitation or contract will be made with insurance agents to promote program membership. Why am I saying this? Because a lot of DPC physicians in this room have been approached by various insurance salesmen wanting to do various things related to marketing their practice. And the more you get involved in that, the riskier things become, not only with the insurance commissioner, who rightly will argue, if you have an insurance salesman selling your product and you're telling me it's not insurance, this is a little confusing. But also, it probably runs afoul of your state's fee-splitting laws, depending on how you've structured your relationship to pay this person. Because most of these folks want to be compensated either on a per-patient basis or based on a percentage of the monthly fee, and when you do that, it's unlawful fee-splitting with a non-physician in a lot of states. Illinois also has an insurance commissioner letter, and this was thanks to the efforts of some folks at the Illinois Academy of Family Physicians. They wanted to see more of this in their state, and they just wrote a letter asking if they could get an opinion, and they got a nice, helpful opinion, and that's posted on the Illinois page of DPC Frontier for everybody to reference too. Nothing harsh in that one. And then Montana referenced the same three-part definition that we've had on DPC Frontier for a while, and this was fun. The Montana governor is the only governor who's vetoed direct primary care not insurance law, not once, but twice. The first time he vetoed it, he was clueless and it was kind of a bad bill. The second time, it was just him being partisan, I suppose. For some reason, it became partisan in Montana, even though it was bipartisan, with no votes against it in multiple states. But this guy, this insurance commissioner in Montana, is an elected insurance commissioner, not one that's appointed by the governor. And he actually ran, in part, on correcting this issue. He used to be a member of the legislature, and he switched over to the insurance commissioner. And then after he got elected, he put out this guidance. So even though the governor doesn't like it, here it is. So he's said written agreements which meet these criteria and clearly outline primary care services under the agreement are not insurance products as regulated by their insurance bureau because no risk sharing or indemnification is involved. If you vary from this or if you decide to become an HMO, then we can come after you. But if you're following that three-part definition, you're good to go. So that's there as a reference as well. So how the heck do we summarize all this? If you're looking for a slide to take a picture of, this is the one. This is not insurance, and it sort of summarizes almost every reg, every state reg you could have in terms of what the insurance commissioner would want. So they want you to be able to terminate the agreement at any time. That's for both you and the patient. If you don't like each other, you ought to stop it already. And arrears means payment after the fact. So if patient's paying you after the fact, you don't have to worry about an escrow account. You don't have to worry about complaints that money wasn't refunded that should have been. And the insurance commissioner doesn't have to worry about you signing up 2,000 people and then quitting month 2 and moving to Guam. So you want to define your scope. The narrower it is, the happier the insurance commissioner is. The broader it is, the happier your patients are. So that's a balancing game. Fee description, say what it is. Is it monthly? Do you have an enrollment fee? If you want money up front, have an enrollment fee. Don't tell them that part of the monthly fees cannot be refunded. That looks clunky. And itemize your fees as often as you can. So that might seem like a weird statement coming from me in this room, but I'm not talking about procedures. If you're going to do an abscess, incision, and drainage, you ought to include that. If you're going to do an EKG, you ought to include that. If you're going to do a lipid panel, if you're going to do a PSA, then I would not bundle those things because you're not doing them in your office unless they're point-of-care labs, which are less reliable anyway. You're sending those out. And when you send those out to LabCorp, Quest, whoever, you're at risk that LabCorp or Quest could either not do the test or that their price is going to go up and that kind of thing. So several state insurance commissioners have commented that they don't like it when you bundle the labs into the monthly fee. I think it's a chance for you to itemize and brag about the $3 CBC anyway, so that's an easier way to go there. Capping your number of office visits and total panel size, we mentioned that earlier. Those don't need to be low numbers, you just need to have a number. Promise that you won't do double dipping. Disclose it's not health insurance. Disclose it's not an ACA plan, which won't matter in 2019 anyway since the tax is now $0. Disclose that you are out of network, especially with HMOs, and I would brag about that too. Disclose your status with Medicare and Medicaid, and you need to pay close attention here, especially in states like Kentucky and Colorado, where it's illegal to privately contract with any Medicaid patient regardless of your status. Medicare, you need to pay attention to if you've opted out and how you're going to deal with that. And don't compensate brokers to sell your DPC memberships. They get paid in lots of other ways, and it's probably unauthorized fee splitting. Okay, don't bundle, I already got to that. So a little bit more on the bundling, because I think we haven't discussed that in detail previously. Labs, you'd be subject to risk that the prices would go up. Same thing if you're going to do that with medications. You may not have Amends to always rely on, or there may be a shortage of XYZ medication that you've previously been giving away because it was dirt cheap. Radiology, the same thing. Even if you have a local group that you like, I would not try to bundle that into your monthly fee, even the basic things like chest x-rays. It starts to make you look more and more like an HMO also. Consultations, I've heard some people talk about having a dermatologist come into their office once a month for fancy procedures they don't necessarily want to do. That's fine, but those still need to be an itemized charge. I would not work that into your monthly fee. It starts to look like an HMO again. Urgent care coverage. I've seen some DPC practices, especially if you're a standalone by yourself and then you come to a conference like this. The issue is, what do I tell all these patients? I told them I had 24/7 access and now I'm out of town for a few days. What if they have a laceration? What if they need to go to the urgent care and they get a $150 bill? Darn. Don't reimburse that. You start to look like insurance when you're reimbursing that. And urgent care promises are what gets unwanted attention from the insurance commissioner as well. Everybody in this room knows that 90% of the value, 90% of the savings is related to chronic care management. It's not this urgent care avoidance. And you can usually triage a lot of that via phone. But if they do ultimately have to go, they have to go. And you shouldn't have promised them anything otherwise. Things that you could bundle, I think I already mentioned some of these. In-office procedures are easy if the lab's done entirely in-house. If you own your own radiology equipment, then that's easy. So this is a little bit of a digression, or a few slides. There are some undisclosed risks that can happen as you open your own practice, be it DPC or otherwise. And I've seen some of this happening to physicians, and I want to disclose these risks because it's my job as an attorney to issue spot. So that's what this is about. I call it license lending. I'm not really a fan of it. With physician's assistants, you're doing that in any state that you sign an agreement to oversee their work. And I think we all understand that. That's the nature of the role. And if you want to do that in your practice, that's fine. Nurse practitioners, that's the case in about half of states. The other half, which I've got a slide coming up on, they have independent practice rights, so technically you're not overseeing them and you're not lending your license in some way. Missouri has a new exception called assistant physicians, and there are DPC practices that work with them there. That's for physicians that did not get a residency and still want to find a way to use the medical degree, and it's almost like an old apprenticeship model. We can get into that more in Q&A if folks are interested. Residents, of course, if you have those in your practice, then you're overseeing them. The ones people don't think about as much are the anonymous consultation services, so I'm going to get into that a little bit here. So you need to know when you're actually lending your license. You need to know if your malpractice covers it, and if your state medical board approves of what you're doing and how you're lending it. So there's an overview of where nurse practitioners have independence. The green states they're totally independent, so technically there does not need to be an overseeing agreement. And then yellow is reduced and red is there certainly has to be strong oversight. So what about these anonymous consultation services that are becoming more and more popular? There are lots of them out there. It's essentially paying for a curbside consult. But if you look at the fine print, it can sometimes be concerning. So they're telling you up front that they don't want you to use it for diagnostic or treatment purposes, which I'm pretty sure is how you're going to use it. And that you're going to take full responsibility for your treatment decisions. So you don't have a name on their side. They don't really have your name, I don't think. But if the patient's aware that this is going on and there is a bad outcome, and if you've charted in your notes that you used said service, then if there's a bad outcome, the attorney's going to try and get at everybody. But you're telling them in most of these agreements that you're not even going to mention this, and they're also requiring that you will pay and indemnify them for any losses that result. So anybody who tries to get back at this organization for their involvement in whatever the malpractice claim was, they're going to turn around and try and say you're responsible for that as well. I don't know if they'd win. I don't know of any cases that have been litigated on this particular issue, but I'm not sure your malpractice would cover it either, because they may not realize what's going on. I think it's one thing to take a consult from someone you know and trust. We probably all do that in this room on a regular basis in various forums. And whether or not we buy into that advice often depends on the name behind it. So you need to be aware of that when you use those services. This is a comparison to health sharing ministries. So if you can remember our DPC slide a minute ago, a lot of these orange states look similar to the green ones that we just went over. And this was an excellent study, and it was put out in August of 2018 by the Commonwealth Fund. And it's worth looking up. I've cited it on DPC Frontier also. So in every state in this country, you can now be a member of a health share. But it wasn't easy for them to get there. And they had to fight not insurance arguments in every state, similar to direct primary care. Many of them were litigated at the Supreme Court level in a few states. But the ones that are orange ultimately were corrected with a legislative passage. So why am I pointing this out to you? Because if you were in a state that was green earlier, and you've got an orange state here, then your state already has an appetite, if you will, for these kinds of corrections. So if we can go back and forth a couple of times there, and then I'll highlight some of the states that I think are ripe for further change and further corrections on a DPC not insurance basis. So there have been discussions in several states, a few of them on the board here, but we're close to a tipping point where I think we've won this debate, even if we don't get laws passed in all 50 states, just like the health shares got there without necessarily passing legislation in every state. The ones that are bolded here, Alaska, South Dakota, North Carolina, I think would be fairly easy, easier than most, and are worth pursuing. Illinois would be tougher, but they already have guidance on the books. Georgia, there's been some attempts blocked by Anthem, and Kim Korb has been leading the charge in Pennsylvania, but that's been a little bit tougher as well. I'm just going to list a few other states in case folks from these various states are in the room. There have already been discussions in the following states: Hawaii, California, Minnesota, Wisconsin, New York, Vermont, Maryland, and New Jersey at various levels, usually without a full proposal. I'm not aware of any talks that have been held in Nevada, New Mexico, North Dakota, Ohio, New Hampshire, Delaware, or Rhode Island. Okay. So I already kind of spilled the beans there. I think we're doing well. I think we'll get a few more, maybe 30 to 40 at one of these days, but I doubt you'll ever have explicit law in all 50 states on the issue. Okay. So where are we at from a federal standpoint? So we were promoting the Primary Care Enhancement Act, which is H.R. 365. That got changed in a lot of ways that nobody in this room would like. And now we have it as part of a clunkier H.R. 6199 that has passed the House and is awaiting consideration in the Senate. Why the heck did we have this legislation? Because the IRS sees direct primary care and gets really confused and has no idea what it is. They created two problems in their confusion. One is a 223C problem, the second is a 213D problem. The 223C problem is where they look at DPC and call it a kind of plan. They're not even saying it's insurance, because we've already won that debate at the state level, and it's not their federal jurisdiction to say what is or isn't insurance. They're just calling it a plan. And by calling it a plan, they view it as a $0 deductible plan, which means you're not eligible to have an HSA. Because your plan for an HSA eligibility needs to be $1,300 or higher for an individual, and now they think you have one with $0. So that's the first problem. So once you're a member of a DPC practice, they argue you can't continue to fund or use that HSA. The second problem, assuming we get over 223C, is that they view the monthly payment and say, we're not really sure what that was for. We don't know if that's a 213D medical expense or not. I think that's the weaker argument of the two by far, but H.R. 365 was our effort to correct both of these simultaneously, and it was morphed a lot and went into 6199, and we'll get into what some of that language looks like. Lee Gross has done a lot of great work pushing to correct these issues. I don't know if he plans to talk about it here, but we all need to give him a round of applause for those efforts. And he's doing it again later this month, so he's still at it. The budget deadline is December 7th, so maybe there'll be some action out of the Senate before then. It's hard to say. And then there have been several executive orders out of the White House that are not discussing this HSA issue per se, but they're discussing issues that are ancillary to DPC. So what does 6199 do right now? It's got three problems that I'm going to highlight. I think it's still worth supporting and trying to correct. So 223C, it amends that provision. So this was the gap plan problem we just talked about. Direct primary care service arrangements shall not be treated as a health plan. Okay, that's simple enough. And then they went on to define what that is and sort of unfortunately limited it to a rather narrow definition of primary care, which we'll get to on the next slide. And then they said, this is my legal problem with the bill that I think a lot of people would gloss right over, is that they said an arrangement under which such an individual is provided medical care as defined in Section 213D, consisting solely of primary care services. So they used to define primary care before Dr. Gross made some corrections. They defined it based on some CPT codes, which were potentially problematic for other reasons. Now they've referenced 213D, which would be fine if they would also correct the 213D problem. But right now the IRS says we're not in 213D either. So if we win this battle, we still may have a 213D hurdle if we don't make a few more corrections to the bill. I don't know if anybody can follow that logic. It's a little circular and annoying. But that's where it stands. How did they define primary care? They said it's a specialty designation, not tied to board certification apparently, but a specialty designation of family medicine, internal medicine, geriatric medicine, or pediatric medicine, which is fine if you're an IM subspecialist and you wanted to come back into this, but for a variety of other groups, maybe an occupational medicine physician that was residency trained that way, this could be problematic, and it's just doesn't need to be that narrow. And they also had, this is what will annoy most of the folks in the room with a cursory reading of the bill, they've got a $150 fee cap. And this is absurd. None of the states decided to do this, but at the federal level they decided it was rational. The states do not feel the need to narrow our scope based on price. But that was the logic for having this in the bill at the federal level. They said, well, we don't want your scope to go beyond primary care, and if we put a cap in there on a monetary basis, then we know you can't start doing things we don't want you to do, like an appendectomy in the office. So that was the logic behind this. 99% of people in the room are not going to be bothered by this amount, but it's still there. What do you do if you're currently charging $200 a month and you want to get in this bucket? Well, then you need to go down to $150, and then you'd need to probably start charging more itemized fees for stuff you didn't used to itemize. That's how I would respond to this if I were in a practice that had a setup that way. So maybe the EKG used to be free and now it's $20, example. Scope limitations, these actually weren't too bad. And this is where, my counter argument to them was you don't need the $150 because you have this specified over here. You've already told us that we're not going to do general anesthesia, and I don't think anybody's upset about that. We're not going to do bundle prescription drugs into the monthly fee. It's fine if you dispense them, but if you bundle them in, then they're concerned, and that you're not bundling labs in either. So, suggestions to the Senate if you decide to contact your senator, which you should. Please correct 213D and make it clear that this is not a medical expense. Not only does that get rid of some circular argument that I just described to you, it means you correct the HSA issue and simultaneously correct the HRA issue. All those other things that employers are going to ask you about, they all reference 213D. So, okay. Presidential executive orders. What the heck are these about? Multiple employer welfare arrangements, MEWAs, has anybody heard that term thrown about? And association health plans, AHPs, short-term limited duration insurance plans. We're going to get into some of these definitions so that you hopefully understand this lingo. So MEWAs are arrangements where two or more employers pool their contributions to benefit a group health or other welfare benefits such as dental, vision, life, disability to their employees. So these have been around a long time, and the laws around them have changed a little bit with the executive order. They could be self-insured or fully insured. The ones that are approaching you are much more likely to be self-insured. If they're fully insured, all those savings, all that downstream spending that should be decreased is going to the insurance company and not the employer. So the self-insured groups are the ones you want to watch out for and look to join your practice. So small employers can now find themselves under ERISA regulations, which is helpful for them for a lot of reasons we can get into later if folks want to talk about that. MEWA is not necessarily the same as a MEP. Those are used and maintained by two or more employers for the purpose of pooling investments and sharing administrative costs. So MEWAs also reference ERISA. And how does ERISA affect your DPC practice? ERISA has been around a long time. When I first learned about it in law school, I hated it. I still sort of hate it, but it's got some good aspects to it as well. The reason I grew up hating it was because when you have a patient who has health care under an ERISA plan and you have a prior auth denial that causes a bad outcome, the patient can't get after the plan for more than the cost of the procedure. So in plain English, you have a patient who falls off a bike, has a cranial bleed, you send him to the ER to get a CT, and for some reason the plan gets in the way and blocks this head CT. It's a silly example because even the worst HMO wouldn't block a head CT in this instance. But if they did, then the failure of this CT to go forward as you intended could still come back on you as a physician, unfortunately. So you still have malpractice at play here. And if they sued the plan, they could get the value of the head CT and damages. And that's it. Doesn't matter that they had a bleed that's made them quadriplegic or what have you. So there's no economic damages coming back at the plan if it's purchased under ERISA. Had they bought that same plan on the exchange or independently in some other forum, then they could go after them for millions in damages. But ERISA preempts that. So I have a bias against ERISA because of those problems early on, but those problems are part of the reason that the ERISA plans were always cheaper too, and employers like to use them because they allow them to have a similar plan across state lines. So from an individual DPC practice standpoint, what does ERISA matter to you right now? If an employer is paying the fee for the patient, doesn't matter if it's 5 patients, doesn't matter if it's 50 or 100 that are in your practice, and then all of a sudden the employer goes bankrupt or the employee gets fired, and they want to stay a member of your practice, you need to give them the ability to do that. So that sounds obvious. Why wouldn't you want them to stay in your practice? But sometimes it's not logistically easy, especially if you have a practice inside a large employer, if it's an on-site DPC clinic, or if maybe you've got 4 or 5 employers you're working with and one's going out and another's coming in and your panel's full. So under ERISA, when that patient loses their job, they have the right to pay anybody involved in their care at whatever rate that was being charged or was being paid by the employer. So plain English, they can pay their own insurance premiums, just like the employer was paying them previously. And if the employer was paying for DPC services, they can continue to pay you at whatever rate you were charging that employer and stay a member of your practice for up to 36 months. Okay. Employer welfare benefit plans. This is any plan, fund, or program established and maintained by an employer for the purpose of providing its participants medical services. Why am I giving you this definition? Because if it meets that definition, then it falls under ERISA. So a lot of folks have tried to come up with creative ways to say DPC isn't under ERISA when the employer pays for it, but this is pretty blunt and broad, and I think there's no arguing that it's not under ERISA. Okay. When you're working with a MEWA, yes, this was just changed with a federal executive order, but state regulations still apply. One of the things the executive order did was it made it easier to sell these across state lines, but that doesn't necessarily mean you're selling exactly the same thing across every state. And when you try and add more and more states, then you're adding more and more regs, because if you want your plan to meet all those rules, then it needs to meet everybody's rules. So we'll have to wait and see if they're really offered across the country or if they're offered in certain regions. Association health plans. This is another one that was changed by the executive order. The old rule was that if you were going to form an AHP, you had to have a commonality of interest among the groups. And this was fairly strictly interpreted, so these were not used very often. And the commonality of interest had to be unrelated to the provision of health benefits, which of course is why everybody's interested in them now, is exactly that reason. So how did this change? Now small businesses can band together specifically to buy insurance, and they can start to behave more like the large groups. When they have larger numbers, especially consolidated in a geographic area, then they can start doing stop loss and start bearing some risk. They can self-insure in ways that they would have been uncomfortable doing on their own. Okay. Unfortunately, this is not a decided issue either. It's not. I'm going to jump ahead, actually. I think I like this next slide more. So here are the start dates for those plans. If they were already fully insured, they could be going as of earlier this year in September. If they're going to be new and brand new, self-insured, which is going to be the most popular category, they can't start until April 1st of 2019. If we back up here, this is not something that I would run out and embrace because there's still litigation on it. 11 state attorneys generals and the AG in DC have filed lawsuits arguing that this is inconsistent with the ACA provisions. So we got to wait on that now and see where that lands. I'm sure they're going to try to offer them in some states, but be careful how much you rely on these things. Okay. This is the one, in this new group, these are the ones that are the most exciting to me. Short-term limited duration insurance plans. Historically, they were 3 to 12 months. They could have been offered, several years ago. In fact, decades ago, they were around, and there was actually plenty of fraud in this area. Plenty of insurance companies that started in kind of boom and bust, quick cycles, and states were left holding the bag. So that's why a lot of them fell out of favor. The regulations have changed quite a bit. As part of the ACA, they were encouraged to only do them for 3 months. But now with an executive order, that has changed. So you could squeeze them out to 12 months if you frequently renewed them previously. Now you can get them out to 36 before you have to do a renewal. And what the heck does a renewal mean for these plans? Unless you found an exception and paid to avoid a renewal, it's going to go through underwriting again. And it does that on a rolling 3-year basis, presumably. What does that mean? When you go through underwriting, they're assessing your risk. And these plans do not necessarily cover pre-existing conditions. So whatever you had, if it's something terrible, you're covered for 3 years and then not necessarily covered for that next time it's underwritten, or it might be factored in when the insurance is rewritten every 3 years, unless you paid for an exception to that. So there's going to have to be a lot of patient education if they want to use these things, and they may vary a lot from state to state. They don't apply with the ACA's mandates, obviously, so they could carve out primary care or carve out direct primary care, and it could be quite a customized wrap plan if it's designed appropriately. In 2019, the fine for not having an ACA plan is $0, so there's probably going to be a lot of adoption of these, and I could see these competing with the health sharing ministries that are already doing well with similar freedom, we should say, which can be good and bad, as long as you don't abuse it. So they can charge higher premiums based on your health status. They can exclude pre-existing conditions. They can impose annual or lifetime limits. They can rescind coverage and opt out of certain categories. The biggest difference between that and health shares is that a health share really doesn't even have a guarantee of coverage at all. Historically, they do a good job covering things, and that's why people join them and stay with them. Here, you still should, at least for the categories they've agreed to. So, how will this line up? It's hard to say, but I think more and more people will be purchasing these short-term plans and pairing them with DPC, and consequently, they're going to be asking you as their DPC doc how to navigate this system. So, I want you to be familiar with some of these terms. You certainly don't want to become or try to educate them like an insurance broker, but it's our job to help them navigate the system, whether that's a consult that's too pricey or a procedure that's too pricey, or quite frankly, downstream insurance now. We need to become the experts because nobody else is going to understand this. States are litigating this provision as well in California and Illinois, so we'll see how those turn out. And I think the ironic piece, the theme of this, is that even insurance doesn't want to be insurance anymore. CMS Pilot Updates. They changed their name, so that's nice. They used to sort of call themselves DPC, and they called it Direct Provider Contracting, which was really weird when you looked at their definition of it. They've changed that to DC, which makes more sense because it came out of DC. That's direct contracting. Modified ACO for large practices is what they're talking about. They're talking about modified CPC Plus, and everybody in this room is falling asleep. But they may or may not ultimately come out with a DPC pilot. Those conversations seem to have quieted down, so I don't have a whole lot of updates there. For people that do want to still work with Medicare in some way, shape, or form, but hate the whole coding, and maybe they want to get a little data, maybe they're into geriatrics, I would say look at the PACE program. So what the heck is the PACE program? It's been around for decades. It's the Program for All-Inclusive Care of the Elderly. Historically, most of the patients that were involved in these programs were dual eligibles under both Medicare and Medicaid. And what happened was the government realized, you know what, we're going to spend an awful lot on these patients if they go into a nursing home. They don't want to go in a nursing home. We don't want them to go in a nursing home, but they need a lot of care. And we need somebody who's willing to do all these things. And for some reason, with this particular project, they realized that fee-for-service was a waste of everybody's time. So they ditched that. If you're in PACE program, it's a capitated payment, and there is no fee-for-service. You don't have to do coding. but you are, of course, still in Medicare. But you do get some data that you can track, and certainly you could do that with something called a blue button report. Anybody who has opted out and you have Medicare patients in your practice, if you want to get some data and try and improve their downstream spend, they have access to it, actually. There's a website where they can do this, and I'm trying to look into this so I can give folks more advice on it, but it's called a blue button report, so they can see how much they spent in Medicare 2 years before joining your practice, and they can compare it to how much they spent after. So that could be good data for a lot of folks in this room who've opted out if they have a fair number of Medicare patients. You could get that if you're in PACE, and you can get that even if you're doing traditional DPC. Okay, so this is a newer discussion for most of the folks in here. I haven't gotten into this in prior presentations. Third-party conflicts of interest are all over the place in medicine, DPC or otherwise. And a lot of folks that don't understand DPC and criticize it from the outside do so often on these grounds. So I wanted to include a discussion of this topic. So in traditional third-party fee-for-service, we've got PBMs that are running the show when it comes to pharmaceutical issues, jacking up the prices, hiding everything, and you've got a scattered physician who doesn't have time to look into this, and they're all part of that system, whether they want to be or not. HMOs play similar roles and control care and have exceptions to corporate practice of medicine that are really head-scratchers, and they're somehow permitted. It leads to defensive medicine. It leads to poorer clinical care, I would argue, because you quite frankly don't have enough time with the patient. And that's where a lot of the conflicts of interest arise. The hospital wants you to be as fast as possible. They offer to pay you more if you're faster, and that generally means you do a worse job. In DPC, of course, we've gotten rid of that time issue, and that's the most important one, I would argue. But there are other parties that can come in and muddy the water. Whether that's someone demanding data that's not necessarily relevant, and you've got to educate them on what data is relevant so it doesn't get in your way, or whether it's some other sort of capitated payment that's coming in and changing the relationship with your patient a little more than you wanted. So time. In the traditional system, you have less time with the patient, and perverse incentives come out of this. Patients are underdiagnosed. They're over-referred, which is what the hospital wants, because the hospital employs the endocrinologist that you're asking to treat their diabetes rather than you starting them on NPH. And they're over-medicated because it's easier to click renew than it is to adjust medications. There have been studies on this in several hypertensive journals that you could predict how much the medications were going to be customized based on how much time the physician spent with the patient. Maybe you're satisfied with 142/92 in one setting, and in another you're not because you had time to actually change the med. So it leads to overprescribing. It's easier to just prescribe that antibiotic in the urgent care because that gets you out of the room in 5 minutes rather than taking 10 minutes to educate them about why it's viral. And of course in DPC you can give them your cell phone number and they can call you the next day if they think they're worse, and then you can write the antibiotic. In the urgent care you can't see them again. They paid you for nothing if it's viral in the urgent care, right? So same thing with opioid prescribing there. I call it the don't call me dose. You get that from several patients when they're post-op. They get enough Lortab to last them for 3 months. That's not necessary, but it's done because you don't have time to handle a phone call about a refill. And that's why we have state laws, which we shouldn't have needed in the first place, that tell people you can only write them for 3 or 4 days now. They're making you do something you should have done in the first place. Polypharmacy can be a reflection of too little time. And we should look it up. Attorneys do this more than physicians, unfortunately. I think it's different in the DPC space. We look stuff up all the time. We're constantly looking at UpToDate or some other resource and doing the best we can for our patients. But in a lot of traditional medicine, it's a reflex referral. If they ask you something you don't know off the top of your head, it's a referral. And don't rely on pharmaceutical marketing. I'm going to argue that all of us, including myself in this room, have been hoodwinked a time or two, and I got an example here. Have you been manipulated? So, here's a quiz question. What medication might you try first for a patient suffering from chronic non-surgical neuropathic back pain, also recently diagnosed with type 2 diabetes, likely untreated for several years? I think I know what everybody's thinking. Nobody's going to say it out loud. Gabapentin, right? So what are the FDA indications for gabapentin? Postherpetic neuralgia is one. Partial seizures are one. And how does this medication actually work? What's the bioavailability? Well, at 900 milligrams, which is your 300 TID dosage, you're absorbing about 60% of that, so 540. As you get up to 4,800, you're only absorbing 25%. So that dosage curve falls off. I know that Gabapentin educated everybody that you want to keep upping the dose and upping the dose till you get the desired effect, but you really don't get a whole lot more bang for your buck above 900 milligrams. That's the first point. And it's not more beneficial than duloxetine, which we'll come back to later. How did Gabapentin market themselves? So I'm going to let you read the top part here. I'm going to be quiet for a second and take a drink, and then I'm going to highlight the part at the bottom. So I don't want to see a single patient coming off Neurontin before they've been up to at least 4,800 a day. I don't want to hear that safety crap. Have you tried Neurontin? Every one of you should take one just to see there's nothing. It's a great drug. This was one of the higher-ups in the company. This was part of a lawsuit where they've ultimately paid over $1 billion in fines, and quite frankly, I think they were happy to pay it because they made far more. So it's dangerous in a lot of ways that aren't disclosed, certainly not in their marketing materials. At 900 milligrams, they can lead to as much as a 60% increase in odds of an opioid-related death. In concert with opioids, it's been associated with a 4-fold increase in respiratory depression. Kentucky is the first state of which I expect will be many more that have reclassified it to a Schedule 5, and it already shows up in PDMPs in multiple states. And if you're like me, and when I was in residency before I was doing correctional medicine, and this is highlighted a lot there, people don't think twice about prescribing gabapentin. They don't think twice about it being abused, about it being snorted, about it increasing the chance that a patient would have an opioid-related overdose, or quite frankly, the FDA indications of how it's being prescribed and why it's being prescribed. And that's a reflection of marketing. Here's how it's actually used. So remember the FDA indications: postherpetic neuralgia and adjunct for seizures. Who thinks gabapentin's a great seizure med? Anybody starting it for seizures? Neither were neurologists, okay? So you can see gabapentin's the 5th one over on this slide, and the dark blue is the 3rd one over. That's epilepsy seizure usage, and I'm going to ballpark that at about 3% of the reason gabapentin's prescribed. And then you got about 75% is for pain. Does it have an FDA indication for pain? Have you ever had a patient say, "Gabapentin cured all my pain. Thank you for writing this. It's cured everything"? It just doesn't happen. So again, $1 billion in fines, 57 million prescriptions in 2015. It is and can be a drug of abuse, and people should be aware of that. So that quiz question, the actual answer was duloxetine, because it does have those indications, and it's not abused and wasn't marketed improperly. So another example of one system versus another. Are you screening for colon cancer? And if you are, whose guidelines are you using? Because there's a lot of them, and they do differ. And I'm not going to lecture everybody on this. I'm not an oncologist. I'm not an expert on these things. But I do want to point out to you that if you have a family physician bias, then the group on this page that has the most family physicians on it is the USPSTF. And those are their guidelines, and they consider them all equivalent. And I know most people go straight to a colonoscopy at 50, but all these things are considered equivalent by USPSTF. So it's food for thought. What if the patient's not paying your monthly DPC fee? Does this create a conflict of interest? And it certainly can. You can wind up with the old arranged marriage problem, right? Somebody else assigned them to your practice. They don't necessarily like you, and you might not like them, and that can get awkward. It's a little more awkward if a large employer has forced several of them in there, because then you have 100 at one time. It could be awkward if their grandma forced them in there too, and grandma's paying the monthly fee. But anytime somebody other than the patient is paying it, then you could have that conflict. If you're the only DPC option in your area, then it might be a little more common. If there are all kinds of clinics down the road, then obviously they have a lot of choice, and I think everybody's more likely to be happy. Did the patient really pick you as your physician? I think I've kind of hit that already. Is the patient interested in the cost of care? So that might seem like a silly question, But it's not always the case. If somebody else is paying the bill, then they might not have been thinking of that as a reason to join your practice. And if your practice is oriented around price transparency and you're disclosing these things, then it changes the dynamic, right? Because if I say to you, we're all going to go shopping for clothes, and you're going to get a nice dress shirt today, and it's all prepaid by Lee Gross because he's doing so well, he's just decided to prepay for it, then you're going to want the $100 shirt because you assume it's more valuable and because it's already paid for by somebody else. And if it's something that you're paying for, then maybe you'll join me at the clearance rack, right? So same kind of dynamic here. If somebody else is paying, you need to make sure they still have a reason to pay attention to price because they might not have the same outlook you do. Okay, pharmacy benefit managers. This is probably the biggest conflict of interest that's been overlooked by DC in the past 20 or 30 years, I would argue. There are billions of kickbacks that are not disclosed. Physicians can't get a pin at a conference, but these guys get millions of dollars and it's all exempted. And there's a total lack of price transparency about it. So when you prescribe Harvoni, it might cost $70,000 for the insurance plan, and then there might be an $8,000 kickback to the PBM that was not disclosed to either party. You should make it your goal to get out of that as much as possible, and as DPC physicians, the best way we do this is dispensing medications. I'll get more into that tomorrow on which states you can and can't do it. A lot of these PBMs will own their own mail-order pharmacies. There's a congressman from Georgia, I'm blanking on his name, who is a pharmacist by training, and he's publicly testified more than once that in his independent pharmacy, he's had patients come into the office, try to fill a prescription, they're told that it won't be covered, and as they're leaving, they get a phone call from a PBM-owned mail-order pharmacy saying they wouldn't cover it there, but they'll cover it from the mail order. So that kind of stuff goes on, and it's just stunning that it's permitted. The argument that price is a trade secret is total garbage, and we shouldn't allow it. And there's not competition here either, which is no surprise. CVS, Caremark, Express Scripts, and OptumRx own 85% of the market, and now there's talk of even more consolidation between these entities and the insurance companies, which have routinely sued each other. So in old-style capitation, which is what we don't want to be as DPC physicians, we want a new selected marriage, not the old arranged marriage. These are your common conflicts of interest. And DPC does get rid of a lot of them, but not necessarily all of them. So we can cross out a few there in DPC, but you do need to be aware of these things. Here the incentive is the reverse, right? Patients are going to stretch your scope of practice, and you need to make sure you don't go too far, because they're not going to want to be referred. They're going to want you to do the largest skin biopsy you're willing to do, and you need to make sure you don't get yourself in trouble. A lot of folks that look at DPC and don't like it accuse us of being cherry pickers, and I think that's not the case at all. Eventually we'll be able to prove that with data, but right now it's more difficult. Who are the true cherry pickers? I think the urgent care chains are really the worst offenders. Healthy patients are the ones who are happy there, and they go in and they assume that's what healthcare is in America, and they wonder why the heck all these people are complaining and why it costs so much. And I'd say it's because most of them don't really have a health problem. If all you did was go to an urgent care, then you probably don't have an uncontrolled chronic condition. You probably haven't had to go in and out of a hospital multiple times, and you're probably fairly young. So we need to overcome that, and we need to remind people of what family medicine is, what good primary care is, and just how much we can do. Okay. Here are a few other issues that I wanted to highlight. Corporate practice of medicine, it's ironically problematic. So the notion behind this law, behind corporate practice of law, behind corporate practice of accounting, is that a corporation should not be telling you, a professional, what you can or can't do. And that's why a lot of us are DPC docs, right? We got tired of the hospital or an insurance company telling us what we could or couldn't do. Well, guess who's specifically accepted from corporate practice of medicine? Hospitals and HMOs. By law, they can tell you exactly what to do. But if you get together with somebody else at this conference who's got a few million sitting around, they're a venture capitalist, and they want to help you open a practice, and they want to be a 50-50 owner with you, and you trust them, and you know they're going to leave you alone to do your job, do you have a CPOM exception for that? Nope. Now you have a non-physician who's got ownership interest in a practice. In some states, that's enforced really harshly, and in other places, it's not a problem. North Carolina, I know, has issued guidance out of their medical board that they're very worried about anything that could be seen as CPOM, and they're going to be more aggressive. Ohio, on the other hand, recently repealed their entire CPOM law and doesn't care who owns the practice. So that's something to look into depending on how your practice is funded. Fee splitting, I've covered earlier. If you're going to pay somebody to help you sell DPC, then I think it's easier to have them on some sort of salary, maybe on a part-time basis, but don't literally make it splitting a portion of your monthly fee, because that could get you in trouble. And then rights to medical care, where does this apply? This is not in the traditional DPC setting. There are some limited rights to medical care in the United States. EMTALA is one where you are entitled to an emergency screening, not necessarily treatment. It just entitles you to a screening, and that might be from a nurse, not necessarily a physician. And then Eighth Amendment, which is correctional medicine, not providing care would be cruel and unusual punishment. Okay, so now we're down to high tech. If you're dealing with physicians who are still in the system and you need them for that stress echo or that colonoscopy, and your patient has a terrible HMO plan with a $7,000 deductible and doesn't want to use it and also doesn't really want to lie about it, which is the alternative historically, right? Just tell them you don't have insurance even when you do. How do you get around that? You use high tech. So high tech allows your patient to show up at the office and say, I'm going to pay you privately for this. And because I'm paying you privately, you can't charge my insurance company. I'm demanding that you don't do that. Does the office at the hospital have to comply? Yes. If they're a covered entity under HIPAA, which they all are, they have to comply with this. If you found the rare institution that wasn't a covered entity, I think they'd already be giving you a transparent price anyway. So how does it work? The covered entity must agree to the requested restriction unless the disclosure is otherwise required by law. I call that the castration clause, unfortunately, so we do have a few problems with it. So for the purpose of carrying out payment and for which the healthcare provider has been paid in pocket out of full, or paid out of pocket in full. So here's where the castration clause becomes an issue. Some state HMO laws would trump this law. You'd have to look into those details, and in some Medicaid designs it would trump it. Medicare doesn't, because Medicare has a specific exception to allow high tech to apply. So high tech can apply for anybody under a traditional PPO plan, under any kind of traditional insurance plan bought in the exchange, and most ERISA plans from employers because they've shied away from HMOs. HMOs aren't used as often there anymore. And then whether or not it could get around the HMO or Medicaid law depends what the state said. And the other thing I'll note here on Medicare, this is a little complicated, so I always debate whether or not to say it. But if a patient under Medicare elects to use this, does this wind up creating a broad exception for you to not opt out? And my answer is no, for multiple reasons. One, you still have the obligation to code and charge the same amount of the patient that you would have charged of Medicare. And they still have a right to audit your practice. And it would be hard to have an entire practice and successfully defend the fact that every single one of your Medicare patients was obsessed with privacy to this level. So, high-tech privacy implications. Have the patient sign a request. They have to request this, so you can educate them about it, but they have to be the one signing the request. And you need to have a way to flag this downstream. And I don't have good solutions for this in every state, especially the ones that have mandated electronic prescribing. Because there's a decent chance you're prescribing a medication based on this visit, and when they go to the pharmacy's going to run it through the plan, right? The minute that shows up, they're going to run it through the plan, especially if they've been there before. So you either have to pick a new pharmacy where they've never gone, if you're doing it electronically, and then specifically leave their plan information out, or you write it on paper, so that the patient can show up, hand it to the pharmacist, and tell them they're using their high-tech rights. Okay, so if they're a covered entity, they must have a process. Medicare allows for it. Medicaid may or may not. Certainly a problem in Kentucky and Colorado, where you can't privately contract with them anyway. HMO laws are going to be state-specific. And then private insurance contracts, it beats them every time, and that's the real fun part. Okay. This I think I jumped ahead on as well, so I would not use this as a panacea to avoid opting out. All right, so I got a few review questions, and then we should have some time for Q&A at the end here. Question set 1, should a DPC physician compensate a health benefits broker for marketing the practice? No. Could you share a percentage of your monthly fee with the payment processor? Yes. What happened? Why was that yes? That's true, they're not selling it. That's part of it. But there's a conduit exception there, okay? Because you're already doing that with Visa anyway. If you use any number of the DPC groups, whether it's Atlas or Hint or Twin Oaks or whoever, they're taking a percentage too. So that's okay. Don't let that scare you. Question set number 2. Does COBRA apply if the employer pays the monthly fee? Yep. That's why the patient has the right to pay and stay in your practice, even if they're fired from wherever their job was. Can a patient pay for DPC using their HSA, HRA, or FSA? No. Why not? IRS is crazy, right? But it's a 213D reference. That's the shortest answer to that. 223C is a problem too, but it's only a problem for HSAs. 213D is a problem for all 3 of them. Okay. How long can I have a short-term STLDI plan? Yep. Good. And then you're going to go through repeat underwriting. It used to be either 3 months or a year. Can an AHP or a MEWA be formed across state lines? Yes, but state laws also apply, so they can restrict them that way, and several states are litigating these new options. So pay attention to who's litigating it and what their laws are, and you might be able to predict where they'll show up regionally. Number 3, does high-tech apply to an independent third-party free practice that does not electronically submit health information? That's clunky legalese. Why the heck did I throw that in there? Because I've described something to you there. I've described a group that's not a covered entity, right? If you're not a covered entity, you're not under HIPAA, and high-tech doesn't apply. Okay? So the answer there is no, but a practice like that is probably already giving you transparent prices. Would high-tech beat out private contracts? Yes. Does high-tech work for Medicare? Yes. Does high-tech work for Medicaid? Probably not. And probably not with HMOs either. All right, this is the last group. I thought I'd go clinical for a change. Everybody always wants me to do legal, so I had to do a clinical question. So there's 2 on here that are right answers, so it's a little bit of a trick question. So that's duloxetine and pregabalin. All right. If you do have questions, there's my email, there's my Twitter. I haven't been too active on Twitter lately, but I'll try to fix that. And then a quote that I thought you'd enjoy. I'm happy to take questions.
Okay, we have 10 minutes for questions, and then why don't you sit down and relax? So come up to the microphone, and we'll alternate like we did for the last session. Then lunch is going to get served actually in 8 minutes, and then we are going to come back in here for our lunchtime keynote speaker.
Patrick Roll, Lancaster, PA. Where can I point my patients to find or to look up information about STLDI plans? Is there like an exchange for them or something?
I'll have to get back to you on that. I don't know if I have a good resource at this point. I need part of the problem is they're new. So more of them need to be out there. The few that are there are old, and I've seen marketing from some of them, but I don't have any way to vet them or endorse them, and I don't know of a good resource just yet. There is some of the better data I've found on them was actually out of the AICPA, out of the accounting literature, but I doubt your patients want to dig into that. So,
this microphone.
Hi. So, can you hear me?
Yeah.
I'm Steve Baker, family physician, just opened 3 months ago in Vancouver, Washington, and having a lot of fun. Question, can 3 independent or 4 independent DPC practices band together legally to negotiate, say, with an imaging center for better cash pricing or client billing pricing?
Generally, yes. Where you have to be careful is if you're dealing with a group that's a hybrid and they're not opted out, then they can get into more trouble. I mean, physicians have grouped together in any number of capacities like that over the years. There are ways to do it.
Thank you.
Yes.
Thank you. I'm Ebalora Wine from the Columbus, Ohio area. My question was, as far as 2019 goes, you did kind of allude to this, there are some changes with requirements for mandatory insurance. Could you highlight a little bit about that so we're all aware?
So, can you rephrase that one more time?
So for the ACA, it was required that everybody had to have insurance, but
Right.
there are some changes coming 2019.
Yes.
Could you address those for everybody's knowledge?
So as of 2019, there is no longer a penalty for not having a plan that is compliant with the ACA. So it remains an open question how many of those ACA plans will still be sold broadly and how people will consider them given how high the price is compared to all these other new ones that are out there. In terms of, it's hard to know how quick people will move, how quick employers will move, but I don't know. With DPC generally, remember it was in the Affordable Care Act. I kind of glossed over that today because I've covered it in the past. But it's still possible for an insurance company to develop the older WRAP plan that's designed to pair with ACA plans. And if they did that, maybe the ACA plans would be more affordable and more people are likely to do DPC.
Yes.
Yeah, Brandon Allman from Wichita, Kansas. I had a question about the STLDI as well. It's my understanding that you can, along with the STLDI, that's 36 months, you can buy a rider that says I have the option to auto-renew for another 36 months, functionally turning an STLDI into a plan as long as you want to buy that rider. Is that still legal to do and something that would last longer than that time period?
I think that's part of the litigation, and I agree. I've seen that. You can usually purchase something to avoid going through, a renewal of the policy, which is what you'd want to avoid, assuming you had a bad outcome.
Rachel Shear from, did I cut?
No, go ahead.
Rachel Shear from Ormond Beach, Florida. I had a question about the STLDI plans. Say somebody was diagnosed with cancer and they needed like expensive chemotherapy treatments that are prescription drugs. I think you mentioned that those plans didn't cover prescriptions. So, in event of a catastrophic diagnosis, would they be able to get the care that they need?
That's why you got to look into them. So we're used to states and the federal government specifying all these things have to be covered. And states can still do that with STLDI plans, and so could the feds. But the point is, these are new-ish because the regs have changed, and what is or isn't covered may or may not be what you're used to having covered. You could theoretically buy a policy that's only going to cover you for heart attacks and multiple sclerosis, if those are the two things you're convinced you may or may not get one of these days. So you got to go into it eyes wide open rather than assuming those are covered. Yeah, I agree.
Thank you.
Yes.
So I'm Neil from Hood River, Oregon, been open about 7 months. My question is, as we counsel patients, I get a lot of patients who are asking these questions. Tell me about the health share ministries, tell me about all these other insurance options. And I'm always a little bit worried about the risk that we assume when we have those conversations. I guess the question is, to what degree can we go out and build resources to help our patients find these plans, or is this just something that needs to be a brief conversation and say, go talk to an insurance broker? What type of risk should we be, are we taking on by having these conversations?
Mm-hmm. I think if you're doing it face-to-face, it's just up to you how far you want to go with it each time. I think when you can potentially get in trouble is if you have flyers for specific insurance companies that you're promoting over others in your office, then there becomes there's immediate question from a regulator about whether or not there's some kind of kickback at play that's not disclosed. I think listing almost like a public service announcement, various options on your website and highlighting them as a laundry list as you can see them for people that are interested in price. And you could do that for any number of things. I've got a price transparency page on DPC Frontier, for example, where I just try and highlight all this stuff, everything from a surgical center to a specific, STLDI plan. Hopefully, when more and more of them are out, I could start listing them there. So as long as you're listing them and not endorsing one over the other, I don't see any problem with it.
Yes.
Yeah, hi, I'm Pete Gallup from Savannah, Georgia. Transitioned about 2 years ago to DPC. And my question is regarding the bundled labs that you were mentioning, that they should be in-house, completely in-house. And we provide in-house, quote, in-house labs and procedures and whatever else at no charge or part of the monthly fee. The problem is that the in-house labs, so things like FLPs, CMPs, stuff like that, cost us about $11 each if we were doing them in-house to purchase the thing, versus sending them out. Those same things are probably $2 to $3 each. And so we figured this out after we were offering that in-house to just send it out because we're saving money and we pay for it. Are we violating what you mentioned there by doing that?
All this stuff is relative. I don't want to make everybody in the room paranoid. I think there's probably no way I can't do that when you're issue spotting like this. There's, South Carolina, I remember they specifically commented on it. I think there were a few other states where they said, they don't like you to do that. A lot of practices, they'll have a list of sort of a top 10 labs that they know are cheap, that patients may not know are cheap. And then they say these are included because the patient assumes it's $50 and they assume there's all this extra stuff included there. But yeah, it subjects you to more price risk if it's outside of your practice. So if you're in a state where the insurance commissioner hasn't acted on that in any way, then I wouldn't worry about it. But it's something you gotta take with everything else.
We have time for one more question.
Okay. Corey Annis, I've been open for 3 years in Carborough, North Carolina, and I wanted to ask in terms of conflict of interest and legal problems. If I have a patient who refers a patient to me and they sign up, and I choose to thank the original referrer by giving them a month free on their membership, and I'm not disclosing to them who just signed up, but just thanking them for their confidence, am I going to get myself in trouble doing that?
Probably not.
Why? Thank you.
I don't think there's a big appetite to come after you on a fee splitting basis there.
Right.
Where people are used to being worried about that kind of thing is Medicare. That's an unlawful inducement.
Mm-hmm.
But you're opted out of Medicare, right?
Not yet.
Probably so.
So that's, if you're totally third-party free, it becomes a lot easier to do those things.
Mm-hmm. Okay.
I'll put it that way.
Thanks.
Okay, well, we're going to wrap this up. Let's give Dr. Eskew a big round of applause. Back here at 12. Lunch is being served outside.